This episode is brought to you by Roundtable Group, the experts on experts. We've been connecting attorneys with experts for over 30 years. Find out more at roundtablegroup.com.
Welcome to Engaging Experts. I'm your host, Noah Balmer, and today I'm excited to welcome Professor Mark McKenna to the show. Professor McKenna is a professor of law at UCLA and a partner at Lex Lumina, LLP, a full-service law firm. He's a sought-after IP expert with numerous publications and holds a JD from the University of Virginia. Professor McKenna, thank you so much for joining me here today on Engaging Experts.
Yeah, thanks very much for having me.
Of course, let's jump into it. You've been an attorney for, about 25 years and a professor for nearly as long. How did you first get involved in expert witnessing?
Yeah, thank you. So you're right. It's my 25th reunion this year. So the number starts to catch me by surprise a little bit, but yeah. So I was a full-time practicing IP attorney in Chicago for 3 years when I got out of law school. I was very lucky to work at a firm with some really great, smart people and people who I think gave me a running start in terms of thinking about real expertise in a subject area. And then I started teaching, and I think the answer is like I got into expert witnessing sort of just because at some point people started calling me, and I assume that's true for many people, but like in my case, I think it was I have a particular kind of subject area focus that I've always written in, and that was the origin of original expert witnessing. And then I think after that, it's as I've gotten further into my career and done more practice of my own, and met more other people, I think then it just becomes a little more word of mouth.
So it's not something that you were actively seeking out?
No, actually, I think the first time I got called, it was a former student of mine who was working at a firm, and they had a case that that it was an area that I was working in, and just kind of went from there. So no, I never really kind of actively sought it out, but I do like doing it, when it's a good fit, and it's the right, kind of subject area for me. It's a good sort of muscle to flex in your brain a little bit.
In your practice as an attorney, have you utilized expert witnesses at all?
Yeah, a number of times. I mean, in trademark cases, we work with survey experts a lot. We've worked with experts who who have more marketing expertise, who are, experts in thinking about like the channels of trade that goods get sold in. Sometimes there's some really good damages experts out there. So used all of those. And then obviously in other kinds of IP cases, you have different experts. I was involved in a big design patent case where, one of the questions was about the validity of the claimed design patent. And so we worked with a person who used to be an automobile designer for a long time on sort of, how do automobile designers go about designing new fenders?
What's it like being on the other end of that phone call?
Yeah. Because I practice as a lawyer, I have the perspective of knowing sort of what it's like to be deposed, what it's like to be in the witness chair, and also kind of what lawyers are looking for when they're using experts. And I find that very helpful to me because I think I'm less surprised, I think, by lines of questions, and I have a better sense when I work with experts as a lawyer what the considerations are that experts are bringing and how to ask them questions in ways that let them really show their expertise and get you the kind of answers you're looking for.
How do you cordon off the lawyer half of your brain when you're acting as an expert witness? Obviously you have your own ideas about trial strategy and about trial teams and everything else. But at the end of the day, ultimately we're all working for the neutral truth as an expert witness. But how do you, interact with an attorney without crossing any of those boundaries?
Yeah, no, I mean, it's a really good question. I mean, it's like it's a question of the role. You do have to be conscious of the role, and you have to be conscious of like staying in your lane. For me, a big part of that, to be honest with you, is like having been a lawyer and used experts a lot, I never want to be in the position of an expert of being called out for having left my lane, right? And so I try to be very conscious of, what are the things that I feel I'm capable of talking about that are within my area of expertise that are appropriate for the case. And when I don't feel like I can do that, just trying to be candid with the lawyers about what, these are the things I feel like I could say in good faith, and these are the ones that I can't. And then, if this trial strategy is like helpful, then that's a different kind of expert role that I've also sometimes play, which is like a consulting expert rather than
Sure.
being a testifying expert. And I like that role too. It's just a different one. And so you have to kind of be clear about which one you're in.
Are there any unique considerations vis-a-vis like Dobert challenges or, just impeaching your expertise in general that comes along with being a lawyer and an expert witness at the same time?
Yeah, I think for me, the thing that I try to be the most conscious of is like making sure that when I'm acting as an expert, that I'm not crossing the line in making legal argument, right? Because that's not the role of an expert, and it's also, but because I do that in the rest of my life, I think it's a thing I try to be very conscious about and be sure, like, am I giving expert testimony on something other than what the legal argument is? There are some unique circumstances. I've been an expert in international arbitrations where actually the thing that I'm hired to do is opine on the legal questions, like because
Sure.
that's relevant. But when you're doing it in federal court, then it's a different role. And so uh, I think for me, having both of those hats, that's the thing I try to be most aware of.
Arbitration and alternative dispute resolution are an interesting topic. What are the differences between being an expert witness in a typical court matter versus arbitration?
Yeah. I mean, so I think that is the biggest one, which is that sometimes in arbitrations, you get hired to be an expert on the law,
Right.
um, especially when it's an international dispute like that. And so that's different because you're trying to. For me, it's like because I'm also my full-time job is as a law professor. Sometimes I feel like in the international arbitration context, what you're doing is like treatise writing, right? It's like you're trying to do the best job you can to explain the legal principles in the case, but not making the legal argument, more just being like, this is sort of how I think the best understanding of what the legal rules are and how they would apply in this circumstance. Usually in an ordinary litigation in federal court, that's not the role of an expert. That's what you do in legal briefs. And so what the expert is doing is bringing expertise that might be on particular questions. So I've been an expert in a case where the question that I was involved with was about fraud on the trademark office. And what I was being asked to do is kind of explain how file histories work at the trademark office and how the trademark office deals with the. So you need somebody who has lots of experience with the legal system, but I wasn't making the argument about fraud. I was trying to explain um, the context in which like some of these things were being presented.
Sure.
Um, so I think that's the biggest difference. And I would also say, arbitrations, you know, uh, almost always when I've done an arbitration, I'm writing a declaration or I'm writing there's not live testimony, there's not depositions, and so there's differences obviously in the what's entailed in doing it, and then obviously big differences in state and federal court too. So
It's a more streamlined process for sure. Have you
yeah.
done a lot of international work or work in venues outside of your hometown?
I haven't done a lot of them. I think I've been an expert in two or three international arbitrations, but I was an expert also in a case that was filed in the United Kingdom.
Hmm.
There was a trademark slash kind of what we would call in the United States like a right of publicity case, but mostly as a trademark case over there between someone who had created a fashion line and used her own name as the trademark and then had sold that company, including with its trademarks, to somebody else. But then the fashion designer, being a designer, wanted to also continue being able to make other clothes and use their name. And so this conflict arose, right, between the party that had acquired the company with her name and her acting as a designer. So I've done that a little bit, uh, where so where I can do that, I find it really interesting to do the international work because sometimes it gives you a nice little exposure to the way things are or are not the same in different places. But yeah, I think people who do a lot of international arbitration work, that's kind of a lane that they find themselves in a lot.
Is the international arbitration situation similar to the UK legal system in as much as they tend to have court appointed experts rather than party appointed experts?
In the case that I'm talking about, that I was hired in the UK, I was hired by party.
Okay.
But I do think you're right that the UK system in general is a little bit more skeptical of privately hired um, experts, and it is more likely to do what you're describing. In fact, I think in the trademark context, the UK often will just be like, there won't be surveys in this case. There won't be survey experts. Some of that's the cost question, but some of it I think is also, you know, questions about what party-driven expert witnessing means in a case.
Absolutely. I recently wrote an article about Rule 706 style court appointed experts. It's not something that comes up very often, but
Yeah,
it's something that can happen. And it did remind me of the UK legal system a little bit, the
yeah,
way that they do that.
yeah.
Um,
Having done this a long enough time now, I now know a number of people who are federal judges, including friends and classmates of mine. I actually think a lot could be gained in a lot of American contexts, at least the ones I know best, by having the court hire the expert and going that route. I think we might get less strategic expert witnessing that way, and I think we might get better information. And then, of course, the parties could both participate in sort of like interrogating that. But I think so. I would actually love to see more of that. And you're right, as you're right, courts have the power to federal courts have the power to do it. So.
Absolutely fascinating topic. Let's talk a little bit about preparation. When you are getting ready as an expert witness for cross examination, what are the sorts of things that you like to see an attorney do? And also, as an attorney, what do you like to do to prepare experts for difficult cross or for depositions or for any really tense situations in court?
Yeah. So, just to return to a question you asked a minute ago, I would say being a practicing lawyer, for me, is helpful in that respect because sometimes the tension that comes from that experience is like unfamiliarity with what the litigation process is like, or unfamiliarity about kind of where questions might be coming from. But because I've been the lawyer on that side, I think I get less surprised by what. And so that just depending on what you're after, I think it takes the temperature down for me a little bit on that. I would say, like, when I'm an expert, the thing I most want from the lawyers who hired me is I want to make sure that I don't get surprised by something. Like I want to be as well prepared in terms of like I want to see all the documents that are relevant. I don't want you to characterize them to me. I want to read them, right? I want to have a sense of, where am I saying something that I'm making an inference versus like something else. So that's the biggest thing I want is like I want not to be surprised in cross. I think those are the times that are the hardest and me frustrated. If you know what's coming and kind of like, these are the things that I think are the right answers, and also I think these are the ones where I acknowledge that there's either the most uncertainty or there's the most. And I think if you're prepared to do that, a lot of what happens on cross-examination is theater. It's not.
As expert witnesses, do you find it best for them to just simply answer the questions, yes or no? And that if there's a problem, if they feel that there's any conflict in their head, to just let the attorney clean it up on cross? Or should the experts be trying to inject a little bit of this and that if they can kind of see where it's going?
Yeah, I think that's a hard question to answer in the abstract. I think because I'm going to say something very lawyery, which is I think it really depends. So um,
Sure.
I think as an expert, you should never be cornered into answering a question yes or no when it's not a yes or no question. And I think something that the lawyers often do to try to twist what experts are doing is to ask questions in a way that flatten out ambiguities or flatten out complexity. And I know why they do that as a lawyer, but um, so I think experts should not give in to treating questions as yes or no questions when they're not yes or no questions. On the other hand, like I think it's usually a mistake for an expert to try too hard to advocate, on behalf and to be seen like they're fighting. I think it's much more effective, in my experience, to um, try to be professorial about it, right? And to say like these are the things that that are important to my opinion that I believe, and then these are areas where maybe it's more complicated than that. And so in those cases, sometimes fighting the yes or no can come across as being more argumentative than is usually helpful.
Let's talk logistics for a moment. When you bring on an expert witness or when you are an expert witness, how do you manage your time? How do you make sure that when you give an estimate of what you expect there to be in terms of time commitment, that is going to be accurate?
Yeah. I mean, so part of the answer to this is just experience. Like I had a case where I was an expert, I don't know, 15 years ago or something, and the case went to trial. To my eye, sort of unexpectedly. I kind of had expected it would settle. And I remember I got a call from the lawyers like 2 weeks before, and they were like, "Well, you just need to come to New York for these few weeks." And I was like, "That my life doesn't work like that. Like I'm in the middle of a semester, I'm teaching." So yeah, so I think one thing that comes from me from experience is like, especially since my regular job has an academic calendar, is just trying to get a clear sense of like what the trial schedule is like, right? When is discovery happening, and does that match my life? And I would say that like when you do things as an expert that are like fairly consistent things, that you get hired as an expert to do a certain kind of report over and over, um, then I think it's much easier for me to anticipate how much time it's going to take me to do that. I will say that my experience of that over time, earlier in my career, was I always underestimated. Um, Always underestimated, and the reports always took me longer to write than I thought they were going to take. And I think there's this like you don't want to like give an estimate where you're like it's just some gigantic number of hours, but on the other hand, like you don't want to do a sloppy job on something, and so it always took me longer. I think I have a much better handle on that and knowing how, but there are some like other important things that are not in your control. Like I don't know how many documents I'm going to need to read until I get a better sense of what the case is or what I'm being asked to do. Now that with electronic discovery and it's so much easier to get so many documents, there's sometimes cases where the fact that you can get them mean there are a lot of them, right? Depends on what you're being asked to do, but so that part of it I feel like is always a little more of a guess because you just don't know. And then of course the things you don't know about, um, you know, how long does the other side think they're going to depose you, right? And how long, on what topics, and um, so yeah, I think it's right. You get better at budgeting time. I've gotten a lot better, I think, at understanding kind of how it fits into the rest of my life. But also like you just, I think, have to know that like every litigator, like there are things that happen in litigation that are not easy to completely predict.
You mentioned electronic discovery. In what ways has technology changed? You've been doing this for a hot minute now, quarter century. That
Yeah.
makes it sound really long. What are some of the differences? Telepresence. We have AI happening now. We have
Yeah.
electronic discovery. What are some of the main differences between when you first started and now? And are they for the better?
I mean, the most obvious thing to say about what's different is that, when I started as a young associate, the way you did discovery was I literally sat in a room with boxes of documents and I read them and I hoped I knew what I was looking for. And that's not how it works now. I mean, the first cut at all this stuff is done electronically, and obviously people are still reviewing and looking at it, but it's all through some, document management system, and it's all. So I think the volume of documents has gone up a lot, but also the tools for trying to search are continue to get better and doing it. The lawyers who really know what they're doing. That's probably a little bit. We used to ask if it's for good or bad. Like I think the answer to that is a little bit of both, right? It's like an explosion in the volume of documents is probably makes cases more expensive and longer than maybe they need to be. But also the tools keep getting better at figuring out how to know what you're looking for, right? What the old system of associate sits with a box of documents and hopes they don't turn over privileged documents depends on you having some confidence that you know who all the people are, right? And what all the names are you're supposed to look for. And now you don't need to do that because you can search on the names and you can easily find it. Huge differences in the way that cases get presented in terms of courtroom technology and that kind of stuff. And that I think is also a mixed bag, right? It's like way easier to use digital technology in the courtroom. It's way easier to um, turn information into the court. But as anybody who practices knows, the court systems are not great. Courtroom technologies vary enormously. Sometimes it might be better just to like use a piece of paper. So yeah, I mean, like the same thing, everything I just said, I could say about the classroom too, right? Classrooms are way more technology. So it's just we're just living in a different world that way.
Yeah, that's an interesting parallel between academia and obviously working in court. What are some of the things that you do as a professor that aid your performance in court, both as an attorney and as an expert witness?
Yeah. Well, I guess I would say that the thing that being a teacher helps me most with is that I'm very used to talking about complex topics with people who don't know a lot about them yet, right? And I'm like, my students are really, really smart kids. Most of them not kids, I shouldn't, but they're really smart, you know. So and they're not starting at ground zero. I mean, I teach a first year torts class, which is closer to ground zero, but everybody who I have as a in any of my IP courses, trademarks or design law or copyright or any of those, like those are students who are, they have some amount of legal knowledge, but they don't know the area. So being able to talk about legal concepts to people who aren't experts in them, I think is the skill of good advocacy. And it's also often what you're asked to do as an expert, right? Is to take expertise that you have and then translate it to a lay audience, or at least to a, a thoughtful judge, but who probably doesn't get a million trademark cases or a million design patent cases or copyright infringement cases. And so um, I think teaching that's what I do every day. And so that's a helpful exercise for me in thinking about it.
Do you find demonstratives to be useful? Charts, graphs, slideshows, videos, models, etc.
Visuals are super helpful. I guess I increasingly as a teacher, I try to avoid using text in the classroom as much. It's not always possible, but pictures are really helpful, right? To be able to like put things next to each other and then to, put things in timelines. And so I think, yeah, visuals can be extremely helpful. Demonstratives can be really useful in sort of making a little more concrete what can otherwise sound very abstract, I think.
Speaking of technology, let's talk a little bit about court demeanor using telepresence. So, if you're on a Zoom deposition, is it different or is it difficult to present yourself the same way? Or is it easier because you're kind of in home base, at your home with your kitty cat next to you, as
Yeah.
opposed to being in court? What do you think about Zoom and telepresence and trying to perform as an expert witness on camera?
Yeah, again, a mixed bag, right? So I think obviously helpful and efficient, not having to travel and not having to, you know, spend the time and the money doing that. For me, I never do that at home because I feel like I don't want the distraction. So I always do them from my office where I feel like it's
Ah,
just like a more, um, professional environment. But, part of any communication in a courtroom is connection with people you're talking to, right? It's eye contact and it's like making this is also a thing I think teaching helps a lot with is um, in the era of COVID, when we were teaching on Zoom, one of the things I found most difficult as a teacher was I had so much harder time reading from the students whether what I was saying was landing for them because a lot of them had their cameras off, or even if they didn't, it was just they would mute themselves, and so there was like speaking into the silence, um, and I think it's hard to know whether you're getting the right level of abstraction or you're saying things in ways when you don't get the kind of cues that you normally get. But on the other hand, when you're being deposed or you're, testifying just by Zoom, like there's also like no other things going on, right? Like you're just answering those questions. You're just focused on it. I think for some people, at least, that can make it less anxiety producing.
let's talk a little bit about billing and engagement letters. As both an attorney and an expert witness, what's the push pull between the two jobs in terms of getting, say, a retainer or a project rate or an hourly rate? How do you like to bill? And as an attorney, do you typically prefer to have your own billing rubric that experts use, or are you okay with
Yeah.
them using their own contracts?
Yeah, I think experts are pretty widely varied in terms of that. I mean, it depends what the experts are doing. Like I have found in general that survey experts usually have an hourly rate, but they usually, if they're doing a kind of survey that they've done a lot before, they have a pretty clear sense of like what the survey will cost and might often, might give you like a flat rate for doing the survey, but then an hourly rate for like deposition and trial work and that kind of stuff. The first thing I'll say is when the very first time I started doing expert witness thing, one of my colleagues said to me, under like every 100% of the time, get a retainer. And I will tell you that that is great advice because um, law firms generally don't want to pay experts directly. They want the clients to do it. And so there's like a pass through that happens. And that means usually sometimes your bill's not at the top of the list of things to get paid. And then, I think the thing as expert, especially, but even as lawyer, that's the least pleasant aspect of any of it is having to chase payment. That's,
Right.
you don't want to do that. So I always get a retainer. What I like to do is just apply the retainer to the final invoice, whatever that is. And then, um, so that makes sense to me. And then, I've done it both hourly and project based. It's I would never do like deposition or trial work project based because I don't have control over how long it takes,
Sure.
but I've done reports on, flat fee where at least where it's a kind of report that I feel pretty confident that I know how long it will take me to do it. Um, so, I just think it depends. It also depends on in terms of your retainer letter, like are you being retained by the firm or by the client directly? What's the payment structure going to be like? So yeah, I mean, I would say that I think most lawyers, and I definitely think as experts, like nobody wants to spend their time billing and collecting. That's not why you do any of this.
It's the
So
least fun part of the job. How do you
yeah.
handle travel expenses? Is that something that you get a reimbursement for, or is that something that you prefer to get prepaid for? Are you able to travel, business class? Tell me about travel
Yeah.
expenses.
Yeah, I guess for the most part, I probably do it by reimbursement. If I'm going to be in a place for a while, I usually will ask the firm or the company just to like pay directly for the hotel room or the flight. But most of the time, it's you're flying for a few days, and I don't mind doing that by reimbursement. But I do think it matters how long they expect you to be there. Um, and I think and people have different approaches. I wouldn't bill a client for business class. I fly enough that I usually wind up getting upgraded, but I don't think that's an expense I would charge to a client. So, but I'm sure there are people who are in very high demand and are flying a lot, and anyone who flies a lot knows that the difference between being in row 32 and being in row 8 is can be a lot when you're landing at midnight. And
Absolutely. Let's talk about a couple general topics. What makes for a positive expert attorney relationship? What are the key aspects, the key defining features that experts and attorneys should be looking out for a productive engagement?
I mean, I think the most like basic level, but probably the most important is clarity and communication, right? So I think having a clear sense of what the scope of the work is and about what you feel confident and comfortable saying and what you won't. Um, and and then lots of open communication about sort of what's happening in the case and thoughts about it. I think that the experts, when I'm a lawyer, the experts I like working with the best, I think, are ones who are really thoughtful about what they're doing. Like, I think there are experts in the world who are very cookie cutter, right? They are what they do for a living is and those people sometimes they'll do a report for anyone who will pay them, right?
Sure.
Um, I want an expert because I think these are the best experts, and I think they're the ones that have the most credibility on the stand, and they're the ones that do the best job. I want an expert who really wants to dig into what are the questions you're asking me to opine on, and can I do that, right? Like, what are the right answers to it? Because I want an expert who feels unambiguously like they're giving an opinion they believe in on the stand, and also who will say, as I've had experts do, and I think it's like, no, I like these are the two things I think are most important. I do think this other thing, but I agree that there's more ambiguity about that. Like, I just think those are the most effective experts, and I think they're the most enjoyable to work with. And I think, you know, I've I've had I've had a lot of those experiences with some really great experts, and I always find them enjoyable. And usually, you learn something along the way too. You learn and so I I hope I am trying to be that expert. When I'm an expert, also that I'm trying to be clear about where my expertise lies and where it doesn't, and also where you know what my role is in the case and what I feel like what other information I need from the lawyers. So I think that's the most important thing. And then I would also say, like, there's a big range in terms of people's clarity of communication on the stand. And people who are really effective are able to, in a very sort of calm way, walk through aspects of their opinion pulled in one direction by hostile lawyers, and who are able to like maintain that and be clear, know when it's time to stop talking.
Absolutely. On the flip side of that, have you had any particularly negative experiences, either with expert witnesses as an attorney or the reverse of that, as an expert witness with bad attorneys?
I don't think I've ever had an experience where the lawyers who've hired me that I've had a negative experience with. I've certainly had bad experiences with opposing counsel, for sure. I think I've had experiences with opposing counsel who think that the right way to deal with an expert is to be badgering and abusive. So those aren't fun experiences. But I've had other experiences too, where I've been deposed by lawyers who I thought were smart and thoughtful and asked good questions, and they were doing a professional job for their client, but they were not misbehaving. And I would say that, as a lawyer, I have never, I think, myself worked with an expert who I thought poorly of, in part because I think I try really hard to do my homework about the experts before we hire them. And I have, now enough people in the world to know kind of who to ask, like, hey, what do you know about this person? And people who I trust. But I've certainly seen, as a lawyer, experts engaged in a case who I think are doing expert witness mill work, right? And they are not being very thoughtful. And I find disappointing. And I feel like there are some great experts out there, people doing really great work. And then, but like everything, there are people who I think are maybe not as thorough as I wish they would be.
Absolutely. One of my favorite questions to ask people is, do you have any pre-trial or pre-deposition routines or rituals? I've talked to a lot of people, and some of them like to drink a lot of coffee but have no breakfast. Some people like to meditate. Some people like to listen to loud heavy metal music before a deposition. Is there anything that gets you centered and ready to go for a potentially difficult deposition or cross-examination?
Yeah, I mean, this is actually just as a life thing for me too. This is true for teaching, but like, I gotta start the day in the gym. Like, I need to do something physical, because otherwise I feel like I get up in the morning and I just sort of like spin things in my head a lot, and it's, and I get it. So like, I need to get out and do something, go to the gym, at least go for a run, something like that. And I find that true kind of all the time whenever I have like a lot of stuff coming up. So I don't know, like some experts who really, like, I've worked with an expert who really like does a whole yoga routine before they go in the courtroom. That's like a way of sort of centering. I've worked with others who, like you said, listen to kind of like hype music. And I think people just, you got to do what works for you.
Absolutely. Before we wrap up, do you have any last advice for expert witnesses or attorneys that are working with expert witnesses out there?
I guess I'm not advice, but I would just say I think that my most positive experiences on either side, either being an expert or working with experts, and maybe this is just like because my full-time job is as an academic, is like I really like experts who are really trying to understand truth, for lack of a better way to say it. Like, they're trying to understand where their expertise can actually help the court make a decision that is the right one, right? Rather than just approaching the whole thing as adversarial warfare, right? Where it's like, I'm just trying to beat the other side. And I think that disposition is one that I hope experts will bring, because it's the reason why expert evidence is supposed to be in trials at all, right? If it's just weaponized, then it's just laundering credentials to give what are essentially lawyer arguments. I hope that we can all do better on that.
Absolutely crucial insight. Professor McKenna, thank you so much for joining me here today.
Yeah, thanks for having me.
And thank you to our listeners for joining us for another episode of Engaging Experts. Cheers.
Thank you for listening to our podcast, Engaging Experts. Our show notes are available on our website, roundtablegroup.com.